Right, here we go with the MPEP 1400. So starting out, this can be about correction patterns. So for the reissue, kind of mentioned that a few times. As far as when it's appropriate, that's the first thing we want to identify, because sometimes there will be questions where it's asking if a reissue or certificate of correction or examination should be issued. So for when it's appropriate, that's going to be if the claims are too broad or too narrow, if the disclosure contains inaccuracies, if the applicant failed to perfect or make a claim for priority, or if there's an incorrect reference to a co-pending application. Now, as far as the oath and declaration, those requirements are going to have the oath or declaration can be signed by the assignee only when not broadening the claims. It has to be signed by all the inventors when broadening claims with the consent of the assignee, a statement by the assignee as well. And broadened claims must be filed within 2 years of issue. Now, the editing in a reissue is a little bit different. So you want to underline for additions, which is the same, but then there's only single square brackets used for all deletions, versus before there's strike through and double brackets used for deletions. But in this case, just single square brackets, and that's it. The process for filing reissue starts with the filing fee. So that's calculated similar to a regular application. Any claim over 20 that's added in there will require a fee. You include the copy of the original application, having one double column side per page. And it has to include the claims, versus with a regular patent, remember, you don't need a claim to get a filing date, but for a reissue, because it's already been issued, the claims are already out there, you must include claims. Also include an offer to surrender the patent and another fee, of course. The consent of assignee, kind of what we talked about a moment ago, unless the oath or declaration is filed as a substitute statement by the assignee, not enlarging or broadening claims. And in that case, you would need the oath or declaration of all inventors if you were broadening claims. The drawings, they have to be submitted as new. They can't be transferred from a parent. For amendments in a reissue, they don't work the same in the non-reissue. So a second amendment in a reissue will also underline any words that were added by a first amendment or bracket any words deleted by a first amendment. So versus non-reissue would simply roll the changes from past amendments, and each new amendment would reflect the previous changes without showing the specific underlining and bracketing. For restriction practices, there's a lot of really interesting examples for this. So basically, you'll find the bulk of it in MPEP 1450, and then the more extensive description in 806 to 806.05. So first off, the examiner may not restrict only the original claim. So if new claims are submitted in an application, but the examiner is restricting inventions which were just with the original claims, that is not allowed, because they're not allowed to go back and redo that aspect of the prosecution, right? That's not what a reissue is about. But a restriction can be made between new claims that are added to the application and the original. But without any reply to the restriction, then the original claims are chosen instructively, and the new claims will be subsequently deleted. There's a little more to that, but so a restriction of a reissue PCT is done through 251. So even though PCT goes through 371 for reissue, since it's been published after the national stage, assuming it's done through 251 and not through the original patent exam. So office actions concerning restrictions with no other errors will result in a divisional application filed for the non-elected claims. And then non-elected claims are then held in abeyance in withdrawn status, and then must be examined within a divisional. If there's no divisional filed, no reissue will issue if there's no other corrections to be made. One more thing to say about this, I would recommend reading this section, because it kind of seems, if I'm reading it correctly, that the application would actually go abandoned if nothing is filed in a divisional, because the reason for a reissue is for an error to be corrected. And so there's no error to be corrected, and you've already surrendered the original claim. If you're not making any action, then the application could go abandoned in that case. The other way it can go abandoned as a result of restriction is if divisional claims are, if the non-elected claims are prosecuted in a divisional application and are then found to be allowed. If they're then found to be allowed, then they can be rejoined to the original claims. But if that option is extended to the applicant and they don't take it, or time runs out for their reply, then that will for sure go abandoned because failure to reply and the fact that there was no other error. So as far as miscellaneous things for the reissue, almost all aspects of the reissue are public except for the interview. So yeah, so everything is public for the reissue because it's already been issued. So if there's a reissue and re-exam proceedings going on at the same time, they can be merged into one proceeding and gone through that way. Reissue exam applications are given priority in examiner's docket. So now we're comparing reissue and re-examination, right? Because these are two ways where the questions can be brought up about an application. So for the reissue, the big difference is between re-examination is that reissue only the patent owner can file. You can broaden claims in a reissue. You cannot broaden claims in a re-examination. I've seen that in a lot of example questions. Make sure you don't get tripped up there. You can file a continuation from a reissue, but you can't do that with a re-examination. All prior art is considered versus with a re-examination, you're limited, and as we'll see in a second, with the prior art. Automatic extensions are available in a reissue. A mistake is required for that to be filed. For re-examination, the big differences are kind of pretty much the opposite of these. So basically anyone can file for re-examination. Only patents and printed publications are considered in a re-examination. So if you have a question that's asking about how a sale should be brought up, then in that case, you kind of immediately know that it's not going to be a re-examination that would examine that. There are no continuations allowed, no automatic extensions, no broadening. So now certificate of correction. So if it's a mistake by the PTO, then it's free. And then as far as what can be corrected by the certificate of correction, when it's an applicant's fault and a fee, you can claim priority when a proper claim is already made in the application. We'll talk more about that in a moment. Typographical, clerical errors, inventorship correction, but the inventorship correction, that one is a little bit different because facts do have to be submitted as opposed to some of the other certificates of corrections. For the statutory requirements of a certificate correction, there's the nature of the correction. It must be clerical or typographical or of minor character, and it must not include new matter, re-examination. So kind of the reason for including those is just knowing that if the petition for a certificate of correction fall outside any of those requirements, then in that case, it would be rejected because of the statutory requirements. So now how to file the certificate for correction of inventorship. So there must be a request to correct, a statement from the person being added, and all current inventors. That's an important aspect. A statement from the assignee, and a fee. Now, if one of those inventors will not submit the statement, maybe they do not agree with that inventor being added to it, then the assignee can just go ahead and file a reissue without broadening, as the inventor would not be needed in that case. So now, how do you file a COC to perfect foreign claim? So it can only correct the foreign priority when the application in question has previously identified the application by number, but neglected to file a certified copy. So if you remember the timeline for filing a certified copy, it had to be filed within the 16/4 deadline. So 16 months after the effective filing date, or 4 months after this filing date, this application, whichever one is later. Then a petition under 1.55F is required with a fee. And if the claim was not made in the original application, then you have to file a reissue. Now, if a claim would put application in a position to need re-examination under old laws, especially pre-AIA, then a reissue would have to be needed instead. So that's going back to that statutory requirement. If any sort of re-examination is needed with the addition of a priority claim, then you have to go through the reissue process. Now, for perfecting domestic or provisional priority, there's a lot of different details to this, and I would definitely recommend reading this. So this can happen if there's a failure to make a reference in a co-pending application or it was incorrectly referencing domestic. All the rules of 1.78D must be met and fulfilled. So those are ones like common inventor, filed within 12 months of the original of the application claim priority. Those are kind of some of the aspects of the 1.78 condition. The priority is appropriate per MPEP 211, so similar rules. Then there must be a petition for unintentionally delayed claim and a fee. Failure for prior provisional, or it was incorrect for prior provisional, and all the rules of 1.78 met and fulfilled. Priority appropriate, unintentionally delayed, fee. Failure for international, same thing, except for the designation of states. You have to prove the priority is appropriate, prove that the U.S. was designated. And that's out there. So then disclaimers, there's a couple different types. So if you're only giving up specific claims, that is done in statutory versus terminal disclaimer. Remember, that's what you use to overcome non-statutory double patenting. That's when you give up an entire term of a whole patent. So then how to receive a statutory disclaimer. One or more claims, or when would you have to give it? One or more claims must be considered unpatentable by honest mistake. You would have to pay a fee and then file in writing to be recorded at the PTO. So now, as far as when a claim would be invalid, if there is a failure to file an interference, so the examiner says that these claims need to be copied to file an interference, failure to file that would lead to these claims being invalid because they were under a statutory rejection elsewhere. Failure to respond to a rejection or appeal rejection of a claim copied for interference. Now, can a claim in an application be disclaimed? No. In this case, it would just be canceled. Disclaiming is only going to occur in an issued publication, an issued patent. That's never going to happen in an application. And it must be signed by an applicant or practitioner. So jumping back to reissue real quick. So the timeline for the reissue. So an application reissue is first announced in the official gazette after it's filed, and then that starts a 2-month time period before the examiner will act on the application. During this time, a protest can be filed, but they have to be very, like a protester has to be very intentional about filing the protest, because that period can be waived or shortened because the examiner is trying to get it through as soon as possible. And so if the applicant requests it to be waived or shortened, that a lot of times is granted. That protest can be filed through the pendency, but it has to be filed before the date of notice of allowance. The prosecution of reissue is conducted similar to the original application, but the applicant is provided 2 months to reply to most office actions through litigation, which may come up. And that is it. So hopefully that's helpful. Again, not a long chapter, so definitely worth skimming.